My presentation to our subject problems in criminal law procedures and evidence is the following. So we will first discuss the entrapment versus instigation. So we will first discuss regarding the definition of the instigation and the entrapment. So instigation is the means by which the accused is lured to other meaning of lured is to provoke or to incite and to the commission of the offense charge in order to persecute him. On the other hand, entrapment is the employment of such ways and means for the purpose of trapping or capturing a lawbreaker. So, in this definition of instigation, it is considered punishable by our law. And entrapment is legal. Ito ang ginagamit ng mostly ng mga enforcers natin to apprehend some drug users, drug possessor, and then including all those related to RA 9165 or any crime that was committed. So I have here an example for us to understand more regarding the instigation and entrapment. So we will discuss regarding the people of the Philippines versus Bartolome. So on August 2003, at around 1 a.m., an informant went to the Anti-Legal Drugs Special Operations Unit or ADSU and Caloocan City to report the illicit drug dealings of the accused on the Reparo Street, Bagong Barrio, Caloocan City. Acting on the report, Police Inspector Cesar Cruz of ADSU immediately instructed some of his men to conduct a bypass operation against the accused. During the pre-operation briefing, the bypass team designated P1 Borban Paras as the pursuer buyer. Paras was given 100 bail that he marked with his initial BP. It was agreed that the informant would drop a cigarette butt in front of the suspect to identify him to Paras and that a Paras would scratch his head to signal to the bypass team that the transaction with the suspect had been consummated. The operation was coordinated with the Philippine Drug Enforcement Agency. So upon arriving at the target area at around 2 a.m. of the August 10, 2003, the 10 members positioned themselves in the vicinity of the store. The informant then approached a person who was standing in front of the store and grabbed the cigarette butt in front of the person. Paras then, only 2 meters away from the informant, stood grabbing of the cigarette butt. Paras went towards the suspect and said to him, "Pre, pa-score nga." The suspect responded, "Pre, piso na lang tong hawak, magkano ba kukunin mo?" Paras "Ayos na yan, piso lang naman talaga ang kukunin ko." After which, he handed the marked 100 bill to the suspect, who in turn drew out a plastic sachet containing white substance from his pocket and gave the sachet to Paras. With that, Paras scratched his head to signal the consummation of the sale. As the other members of the team were approaching, Paras grabbed the suspect, PO3 Rodrigo Antonio, another member of the team, confiscated the marked 100 bill from the suspect, who was identified as Noel Bartolome Baggio. Paras immediately marked the sachet at the crime scene with Bartolome's initial NBB. So Inspector Cruz later requested and writing the Painting Crime Laboratory in Caloocan City to conduct a laboratory examination of the contents of the plastic sachet seized from Bartolome. PO2 Rolando de Ocampo, another member of the bypass team, brought the request and sachet and its contents to the laboratory. In due course, Forensic Chemical Officer Jess Abadella de la Rosa of the PNP Crime Laboratory confirmed the Physical Science Report number D-1038-03 that the plastic sachet contains 0.6 gram of methamphetamine hydrochloride, or what we call shabu, a dangerous drugs. So here, the issue is whether the transaction resulting to the arrest of Bartolome is an instigation. It is not instigation because based on the definition of the instigation and the entrapment, legal yung ginawa nila. It is called entrapment. Thus, the accused cannot justify his or her conduct and instigation where law enforcers act as co-principals. The accused will have to be acquitted, but entrapment cannot bar prosecution and conviction. As has been said, instigation is a trap for the unwary innocent, while entrapment is trap for the unwary criminal. Ayun po. So, the accused is a criminal or nagbibenta ng shabu. So, he is liable and committing or violating RA 9165. So, we will proceed to, contrary to Section 5 of Article 2 of Republic Act 9165 and criminal case number 19381, Sindang was charged with violation of Section 11, Article 2 of Republic Act number 9165. So, within the jurisdiction of the said court, the said accused is not then authorized by law. So, then and there willfully, unlawfully, and feloniously possesses one half-sealed plastic sachet containing 0.1 gram of shabu. So, contrary to Section 11 of Article 2 of RA 9165, when arraigned, the accused appellant pleaded not guilty in criminal case number 19351. The same plea was entered by Sindong when she was arraigned in criminal case number 19381. So thereafter, a joint trial ensued. To prove its charges, the prosecution presented the following: Police Chief Inspector the Liana, Police Officer 2 Corsani, Senior Police Officer 1 Germado, SPO2 Ferrer, SPO2 Special Investigator 3 Ernesto Tagle, and Poser Buyer RCB Tobio. So, Ramonito Astillero, Rodolfo Merst, and Jodeto Badaliar, an employee of the Department of Justice, Dumaguete City, the barangay captain of Barangay 2, Upper Look, Right, Dumaguete City, and a medical practitioner were no longer put on the witness stand after parties agreed that their testimonies would be as follows: that they signed as witness, and then to receipt of drugs and other property seized in the presence of the accused appellants on January 19, 2009, that except for Pavilier, who signed the receipt of the Philippine Drug Enforcement Agency office, both Astillero and Merst affixed their signature on the receipt of the police where the accused appellants were arrested, and that their photographs were taken as they were signing the receipt. The accused appellants took the witness stand to fortify the respective defense. So because of that, they are guilty of instigation. Yun po. So, we'll proceed to the mistake of fact. So, in the context of our criminal law, a mistake of fact is misapprehension of a fact which, if true, would have justified the act or omission which is the subject of the prosecution. Generally, a reasonable mistake of fact is a defense to charge of a crime where it negates the intent component of the crime. For us to understand more regarding to this mistake of fact, we will have fearing that the intruder was a robber or a theft, leaped to his faith and called out, "If you enter the room, I will kill you." We have here, regarding this case, we have here the issues. Whether the jurisdiction one can be held criminally responsible who, by reason of a mistake as the facts, thus an act for which he would be exempt from criminal liability if the facts were as he supposed them to be, but which would constitute the crime of homicide or assassination if the actor had known the true state of the facts at the time when he committed the act. So, under such circumstances, there is no criminal liability, provided always that the alleged ignorance or mistake of fact was not due to negligence or bad faith. In broader terms, ignorance or mistake of fact, if such ignorance or mistake of fact is sufficient to negative a particularly intent which under the law is necessary. Ingredient of the offense charged consents the presumption of intent and works an acquittal. So under Article 1 of the Penal Code is the following. Any person voluntarily committing a crime or misdemeanor shall incur criminal liability even though the wrongful act committed be different from the which he had intended to commit. So a voluntary act is a free, intelligent, intentional act and groundly assert that without intention or intention to do wrong or criminal intention, there can be no crime. So since evil intent is dual or an inseparable element in every crime, any such mistake of fact as shows the act committed to have proceeded from no sort of evil in the mind necessarily relieves the actor from criminal liability provided always there is no fault or negligence on his part. A careful examination of the facts as disclosed in the case at bar convinced us that defendant Cinnamon struck the fatal blow alleged in the information in the firm believed that the intruder who forced open the door of his sleeping room was a thief from whose assault he was an imminent peril, both of his life and his property, and the property committed to his charge, that in view of all the circumstances, as they must have presented themselves to the defendant at the time he acted in. So God faith without malice or criminal intent and the belief that he was doing no more than exercising his legitimate right on self-defense. That had the facts been as he believed them to be, he would have been wholly exempt from criminal liability on account of his act, and he cannot be said to have been guilty of negligence or recklessness or even carelessness and falling into his mistake as to the facts or in the means adopted by him to defend himself from the imminent danger which he believed threatened his person and his property and the property under his charge. So the judgment of conviction in the sentence imposed by the trial court should be reversed, and the defendant acquitted of the crime with which he is charged in his bail bond exonerated. So we have here the principles regarding this case. So since evil intent is in general an inseparable element in every crime, any such mistake of fact as shows the act committed to have proceeded from no sort of evil in the mind necessarily relieves the actor from criminal liability provided always there is no fault or negligence on his part. Ayan po. So, we will proceed to the people of the Philippines versus Juarez. So, this is the fact. Captain Godofredo Monsod, Constabulary, Provincial Inspector of Cabanatuan, Nueva Ecija, received from a Major Guido a telegram of the following tenor. Information received: escaped convict Anselmo Balagtas with Bailerena and Irene in Cabanatuan, get him dead or alive. Captain Monsod accordingly called for his first sergeant and asked that he be given 4 men. The same instruction was given to the chief of the police, Juanis, who was likewise called by the provincial inspector. So defendants Juanis and Galanta then went to the room of Irene, and on seeing a man sleeping with his back towards the door, where they were simultaneously or successively fired at him with their .32 and .45 caliber revolvers. So the issue here is whether they may, upon such fact, be held responsible for death thus caused to Texan. So, Appellants are hereby declared guilty of murder with a mitigating circumstance. Because ignorantia facit excusal, but this applies only when the mistake is committed without fault of carelessness. So appellant found no circumstance whatsoever which would praise them to immediate action. The person in the room being then asleep, appellants had ample time and opportunity to ascertain his identity without hazard to themselves, and could even effect a bloodless arrest if any reasonable effort to that end had been made, as the victim was unarmed. So pwede naman nilang arestuhin kasi natutulog pa yung victim. So wala namang kalaban-laban why they shot him, diba? Habang natutulog. So pag napansin nila kaagad na hindi yun yung hinahanap nilang tao or criminal, na naiwasan yung ganong pangyayari. And then no unnecessary or unreasonable force shall be used in making an arrest. O, di ba? Hindi dapat gumagamit ng force during the arrest. And the person arrested shall not be subject to any greater restraint than is necessary for his detention. So a peace officer cannot claim exemption from criminal liability if he uses unnecessary force or violence in making an arrest. So two requisites in order that the circumstance may be taken or justifying one. Offender acted in the performance of a duty or in the lawful exercise of a right present. Injury or offense committed by the necessary consequence of a due performance of such duty or lawful exercise of such right of office not present. So according to Article 69 of the Revised Penal Code, the penalty lower by 1 or 2 degrees than that prescribed by law in such case be imposed. So we will proceed different from mistake of law and mistake of identity. So when we say mistake of fact, it arises when criminal defendant misunderstands some fact that negates an element of the crime. So, for instance, if an individual is charged with larceny but believed that the property he took was rightfully his, this misunderstanding negates any intent to deprive another of the property. One important qualification, however, is that this mistake of fact must be honest and reasonable. Thus, a defendant cannot later claim that he or she was mistaken when he or she actually know the situation. Likewise, the mistake must be one that would appear reasonable to judge or jury. If the same individual was repeatedly told that the property was not his and he could not take it, would no longer be reasonable for him to mistakenly have believed that he could rightfully take the property. So, sa mistake of law naman, it is a defense that the criminal defendant misunderstood or was ignorant of the law as it existed at the time. So there is the word what we call onus. It is generally placed on individuals to be aware of the laws of their state of community, and thus this defense only applies in very limited circumstance. For example, while a defendant will not be able to claim that he was not aware that murder was crime, he may be able to argue that he was not aware of some obscure traffic law. Specifically, mistake of law can be used as defense in four limited circumstances: when the law has not been published, when the defendant relied upon a law, statute, and next is when the defendant relied upon a law or statute that was later overturned or deemed unconstitutional. And the next is when the defendant relied upon a judicial decision that was later overruled or when the defendant relied upon interpretation by an applicable official. Additionally, the defendant reliance or any of these sources must have been reasonable, much like mistake of fact. Thus, a defendant cannot claim that he was relying on a case from 200 years ago, when it is apparent that there have been subsequent developments in the law. So it is also important to take note that while reliance on an interpretation of an official may include judges or federal of state agencies, it does not include reliance on the statement of a private attorney. It is therefore important to ensure that any attorney from whom you obtain advice is knowledgeable and trustworthy. Ayan po regarding the mistakes of fact and mistakes of law. So we will proceed to the civil liability arising from criminal liability from Article 100 to Article 113. So Article 101 rules regarding civil liability and certain cases. The exemption from criminal liability established in subdivisions 1 to 5 and 6 of Article 12 and in subdivision 4 of Article 11 of this code does not include exemption from criminal liability, which shall be enforced subject to the following rules. First is, in cases of subdivision 1 to 3 or Article 12, the civil liability for acts committed by an imbecile or insane person and by a person under 9 years of age or by one over 9 but under 15 years of age who has acted without discernment shall be devolved upon those having such person under their legal authority or control unless it appears that there was no fault or negligence on their part. So second is, in the cases falling within subdivision 4 of Article 11, the persons for whose benefit the harm has been prevented shall be civil liability proportion to the benefit which they may have received. So the third is, in cases falling within subdivision 5 and 6 of Article 12, the person using violence or causing the fear shall be primarily liable and secondarily, or if there be no such persons, thus doing the act shall be liable. So saving all this to the letter, the part of their property exempt from execution. So we have general rule. Exemption from criminal liability does not include exemption from civil liability. So, the exemption no civil liability and part, paragraph 4 and 7 of Article 12, paragraph 1 to 6 are not exempt from civil liability, although exempt from criminal liability. So, who are civilly liable for? The first is the acts of insane or minor exempt from criminal liability, primarily devolved upon persons having legally authority or control over him, if it at fault or negligent, if no fault or negligence, or even with fault but is insolvent and there are no persons having legal authority over them, the property of the insane, minor or imbecile not exempt from execution shall be liable. Over 15 but under 18 with discernment. The first is civil code says parent, dad, and then their mom. Guardians also and minors own property or guardian ad item shall be appointed. So final release of a child based on good conduct does not remove his civil liability for damages. So persons acting under irresistible force or uncontrollable fear, person using violence or causing it fear, are primarily liable if there are none, those doing the act. No civil liability in justifying circumstance except paragraph 4 of Article 11. The one benefited by the act is civil liable. Civil liability in case of state necessity. So those who benefited by the act and court shall determine the proportionate amount for which it shall be liable. So if the government or majority of the inhabitants are liable, such will be determined by special laws or regulations. So we'll proceed to the Article 102 of Article 102 of under the paragraph 1 that the innkeeper of the establishment or his employee committed a violation of municipal ordinance or some general or special police regulation, a crime is committed in such establishment. Person criminally liable is insolvent. When all these are present, the innkeeper and the like are subsidiary liable. So the second element of paragraph 2, the element of paragraph 2 also is guest notified in advance the innkeeper of the deposit of such goods within the inn. Guest followed directions of the innkeeper with respect of the care and vigilance over the such goods. And then such goods of the guest lodging therein were taken by robbery with force upon things or theft. When all these are present, the innkeeper is subsidiarily liable. Okay, so no civil liability in case of robbery with violence against an intimidation of person unless committed by the innkeeper's employees. So actual deposit of the things of the guest to the innkeeper is not necessary. It is enough that they were within the inn. So we will proceed to Article 1. So subsidiary civil liability of another person. The subsidiary liability established in the next preceding article shall also apply to employees or employers, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. So we have here elements also under this Article 103. So, employer, teacher, person, or corporation is engaged in any kind of industry. So, when we say industry, it is any department or branch of art, occupation, or business, especially one which employs so much labor and capital or distinct branch of trade. And any of their servants, pupils, workmen, apprentices, or employees commit a felony while in the discharge of his duties. The said employee is insolvent and has not satisfied his civil liability. Hospitals are not engaged in industry, hence not subsidiarily liable for acts of nurses, private persons without business or industry, not subsidiarily liable. So, next. So, we have here the difference of the civil liabilities and the pecuniary liabilities. Civil liabilities include separation and indemnification, while pecuniary liabilities is also same with this civil liability. Civil liability also includes restitution or the return property taken, nothing to pay in terms of money. And when we see pecuniary liabilities naman, no restitution as the liabilities is paid out of the property of the offender. And then civil liability, no fines and cost of proceedings, but and pecuniary liabilities includes fines and cost of proceedings. Ayun. So we will proceed to the Article 5. Restitution how made. So the restitution of the thing itself must be made within or whenever possible with allowance for any deterioration or diminution of value as determined by the court. The thing itself shall be restored even though it be found in the possession of the third person who has acquired it by lawful means, saving to the letter his action against the proper person who may be liable to him. So this provision is not applicable in cases in which the thing has been acquired by the third person in the manner and under the requirements which by law bar an action for its recovery. The convict cannot, by way of restitution given to the offended party, a similar thing at the same amount, kind of species, and quality. The very thing should be returned. So if the property stolen while in the possession of the third party suffers deterioration due to his fault, the court will assess the amount of deterioration and in addition to the return of the property. So the culprit or the accused will be ordered to pay such amount. And the general rule is the owner of the property illegally taken by the offender can recover it from whosoever is the possession thereof. Thus, even if the property stolen was acquired by a third party by purchase without knowing that it has been stolen, such property will be returned to the owner. So if the thing is acquired by a person knowing that it was stolen, then he is an unnecessary and therefore criminal liable. The third party who acquired the stolen party may be reimbursed with the price paid, therefore it be required at public sale and good faith. So there are circumstances which bar an action for recovery. When sale is authorized, torrents title, when the liability to return a thing arises from a contract, not from a criminal act. The court cannot order its return in the criminal case. Restitution may be ordered even if accused is acquitted, provided that the offense is proved and it is shown that the thing belongs to someone else. When crime is not against property naman, no restitution or reparation of the thing can be done. So payment of salary of an employee during the period of suspension cannot, as a general rule, be properly decreed by the court in judgment of acquittal. It devolves upon the head of the department concerned. So the court has authority to order the reinstatement of the accused acquitted of a crime punishable by the penalty of perpetual or temporary disqualification. So, Article 106. The reparation. The court shall determine the amount of damage taking into consideration the price of the thing, whenever possible, and its special sentimental value to the injured party, and reparation shall be made accordingly. So we have here the notes. Reparation will be ordered by the court if a restitution is possible. So reparation shall be first the price of the thing, and then second its sentimental value. So if there is no evidence as to the value of the thing unrecovered, reparation can be made. So payment by the insurance company does not relieve the offender of his obligation to repair the damage caused. The damage shall be limited to those caused by the crime. Accused is liable for the damage caused as a result of the destruction of the property after the crime was committed, either because it was lost or destroyed by the accused himself, or that any other person, or as a result of any other cause or causes. So, ayun po ang Article 106. The Article 107. So, indemnification for consequential damage shall include not only those who caused the injured party, but also those suffered by his family or by a third person by reason of the crime. So indemnity refers to the crime against person, reparation to crimes against property. So indemnity for medical services is still unpaid may be recovered. Contributory negligence on the part of the offended party reduces the civil liability of the offender. The civil liability may not increase only if it will not require an aggravation of the decision in the criminal case, which is it is based. The number of damage for death shall be at least 50,000. So even though there may have been mitigating circumstance, so in addition to this, payment for the loss of the earning capacity for the deceased. If the deceased was obliged to give support, the recipient who is not here may demand support from the defendant. So the spouse, illegitimate and illegitimate descendants and ascendants of the deceased may demand for moral damage. So moral damage may be recovered and the following: the physical injuries, seduction, abduction, rape, adultery, concubinage, illegal or arbitrary detention, illegal search, libel, slander, defamation, malicious prosecution. So exemplary damages may be imposed when the crime was committed with one or more aggravating circumstance. So cannot be recovered as a matter of right. The court will decide whether they should be adjudicated. So we will proceed to Article 8. So obligation to make restoration, reparation for damage, or indemnification for consequential damage and actions to demand the same upon whom it devolves. The obligation to make restoration or reparation for damage and indemnification for consequential damage devolves upon the heirs of the person liable. So the action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured. So the heirs of the person liable has no obligation if restoration is not possible and the deceased left no property. So civil liability is possible only when the offender dies after final judgment. So if the death of the offender took place before any final judgment of conviction was rendered against him, the action for restitution must necessarily be dismissed. So, yun po ang Article 108. So, next is the Article 109. 111 or 111. So, the obligations to make restitution in certain cases. So, any person who has participated gratuitously and the proceeds of felony shall be bound to make restitution in an amount equivalent to the extent of such participation. So, this refers to a person who has participated gratuitously in the commission of a felony and he is bound to make restitution in an amount equivalent to the extent of such participation. So, the third person must be innocent on the commission of the crime, otherwise he would be liable on the accessory of this article. And this article will apply. So the next is the Article 100. We will be so the issue here is whether or not the death of the accused pending appeal of his conviction extinguished his civil liability. So according to the court, decide on the case through stating that the case of Castillo and Sinday Diego in the Castillo case, the court said that civil liability is extinguished only when death of the accused occurred before the final judgment. So Judge Caponan further stated that civil liability extinguished because there will be no party defendant in the case. Di ba patay na nga siya before the final judgment. So there will be no civil liability if criminal liability does not exist. Further, the court stated, it is thus evident that the rule established was the survival of the civil liability depends on whether the same can be predicated on the source of obligations on the other than the late. In the Sinday Diego case, kasi the court issued resolution of July 8, 1977, where it states that civil liability will only survive if death came after the final judgment of the CFI of Pangasinan. However, under Article 30 of the CC or Civil Code could not possibly lend support to the ruling in the Sinday Diego case. Civil liability ex delicto is extinguished by the death of the accused while his conviction is an appeal. So the court also gave a summary on which cases should civil liability be extinguished to with. So death of the accused pending appeal of his conviction extinguished his criminal liability as well as the civil liability based solely thereon. So therefore, Bayolta's death extinguished his criminal and civil liability based solely on the act complained of. So, dismissed yung case. Wala siyang Hindi siya criminal and civil liability because his death is before the final judgment. So we have here the kinds of privilege. We have here the difference of the privilege and the ordinary. So we have here the condition, ordinary mitigating, and the privilege mitigating. Under the condition, upset by aggravating circumstance. Under ordinary mitigating, susceptible, and then privilege mitigating, it cannot be. So ethic of penalty to penalty, it applies the medium penalty in the period does not go down to another period. And the privilege mitigating naman lowers the penalty by 1 to 2 degrees, may go down to another period. And same to the both reduces penalty but cannot change the nature of the crime. So it is both yes. And then the condition applicability naman on the ordinary mitigating generally applies to any crime, but on the privilege mitigating only to particular crimes lang. So we have here an example of privilege mitigating circumstance. Offender is below 18 years old and then crime is not wholly excusable. So the offender is still suffering from mental agony brought by the offense to him. Immediate vindication of relatives or himself of vindication or gave the grave offenses. So there must be the social standing of the person, time when the insult was made, place where the insult was made, and sometimes even the age is considered. So we will proceed. So with that, loss of reasoning and self-control, thereby diminishing the exercise of his willpower. So the passion or obfuscation is not mitigating when committed because in the spirit of lawlessness and the spirit of revenge. This passion or obfuscation cannot coexist with vindication of grave offense, treachery, ganon. So next is the provocation or threat. So provocation is understood as any unjust or improper conduct or act of the defendant party capable of inciting, or imitating anyone. So we will be having this people versus Epifanio Jokno and Roman Jokno. To more understand regarding yung class natin kanina. Okay. So we have here the facts. The deceased Yu Yung was vendor of Sunday goods in Lucena, Tayabas. At about 7 o'clock in the morning of January 3, 1935, Salome Jokno, to whom Yu Yung was engaged for about a year, invited the latter to go with her. Yu Yung accepted the invitation, but he told Salome that her father was angry with him. Salome answered him, "No matter, I will be responsible." At about 6 o'clock in the afternoon of said day, Yu Hyung and Salome Jokno took an automobile and went to the house of Salome's cousin in Pagbilao. As they found nobody in the house, they went on their way out San Pablo, Laguna. On January 5 and 6 or 6 of the said year, Roman Jokno telegraphed his father Epifanio Jokno, who was in Manila, informing him that Salome had eloped with the Chinese Yu Hyung. On the morning of January 7, 1935, Epifanio Jokno and Roman Jokno went to San Pablo, Laguna in search of the elopers. Having been informed that the latter were stopping at the house of Antonio Laico, they went there. Upon arriving near the house, they saw Yoo Hyung coming down the stairs. When Yoo Hyung saw them, he ran upstairs and they pursued him. At that moment, he was overtaken by the accused, who carried knives locally known as balisong of different sizes. So Yoo Hyung fell on his knees and implored pardon. So in the situation, Roman Diokno stabbed him with a knife in the back and later in the left side. Epifanio Diokno also stabbed him once. So Yoo Hyung fell on the landing of the stairs in the balcony and there was again stabbed repeatedly. So the victim later on died. So the issue here is whether the act was committed in the immediate vindication of a grave offense to the one committing the felony. Kung may immediate vindication of a grave of offense. Meron kaya? So according to the court, yes. Diba? So because the presence of the fifth mitigating circumstance of Article 13 of the RPC or the Revised Penal Code that it is immediate vindication of a grave offense to say the accused may be taken into consideration in favor of the two accused because although the elopement took place on January 4, 1935 and the aggression on the 7th of said month of year, the offense did not cease while Salome's whereabouts remained unknown and her marriage to the deceased unlegalized. So therefore, there was no interruption from the time the offense was committed to the vindication thereof. So our opinion, opinion of the court on the point, this point is based on the fact that the herein accused belonged to a family of old customs to whom the elopement of a daughter with a man constitutes a grave offense to her honor and causes disturbance of the peace and tranquility of the home and at the same time spreads uneasiness and anxiety in the minds of the members thereof. So is the people of the Philippines versus Nabora. So the provocation constitutes a mitigating circumstance must, in the language of the law, be sufficient that it is adequate to excite the person to commit the wrong and must accordingly be proportionate to its gravity. In the instant case, it can hardly be said that the acts of the deceased and pointing his finger of the defendant and uttering questions aforementioned constitute a sufficient cause for him to draw out his knife and kill the deceased. So the fact of this case is on the night of December 3, 1940, while the accused Vicente Naboro was taking a walk along the New Lonita, the deceased Domingo de Vera met him near the site of the flagpole and pointing his finger at him, sa accused. So asked him what he was doing there and then said, "Don't you know we are watching for honeymoon here?" Provoked by the attitude of the deceased, the accused drew out his knife and stabbed the deceased on the abdomen and on the other parts of the body, which caused the latter his instant death. An information for homicide was filed against the accused, where it was alleged that he is a recidivist. He having been previously convicted 3 times physical injuries and punished once of robbery, 3 times of theft, and twice of illegal possession of deadly weapon by virtue of final judgment of competent courts. So defendant pleaded guilty to the charge and was allowed to testify on mitigating circumstance in this favor. So the question is whether there is sufficient provocation kaya on the part of the deceased, di ba? May sufficient provocation kaya on the part of the deceased? No, di ba? Because by the defendant plea of guilty, he admits the aggravating circumstance of recidivism and reiteration alleged in the information. In partial offset, he is entitled to one mitigating circumstance: voluntary plea of guilty his claim to another mitigating circumstance that the sufficient provocation on the part of the deceased cannot be sustained. The provocation to constitute a mitigating circumstance must, in the language of the law, be sufficient, that is adequate to exile the person to commit the wrong, and must accordingly be proportionate to its gravity. So in the instant case, it can hardly be said that the acts of the deceased and pointing his finger at the defendant and uttering the question aforementioned constitute a sufficient cause for him to draw out his knife and kill the deceased, di ba? Hindi naman excuse yung or hindi naman sapat na dahilan para patayin yung tao dahil lang sa pag-point ng finger sa kanya or uttering some questions, di ba? So the next is the person was killed, that the accused killed him, that the killing was attended by any of the following qualifying circumstance: treachery, taking advantage of superior strength, in consideration of price, reward, or promise, by means of inundation, fire, poison, explosion, and others, an occasion of any of the calamities enumerated in the preceding paragraph, with evident premeditation, with cruelty, with by deliberately, inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. The killing is not parricide or infanticide. It is murder. So we have here an example: people versus Murray. Esther del Rosario Murray. So victim Murray married defendant Murray, the latter already having 4 children prior to their meeting. The family were living in a 3-bedroom house, all of which found on the 2nd floor. The first, by the couples themselves, second are for the younger children, and the third by the elder children and their maid. So the 3rd room is usually open. So years after George was having illicit relations with a certain Varga, Esther has known of this fact. As positively testified by one, the mother of Varga, Tagli, the Murray's family driver, Esther's daughter Caridad, is near and peer friends of the couple. Furthermore, at the death of the George, Esther, certain Del Rosario, owner of the funeral where George's body lies, to close the coffin. Subsequently, Varga tried to take a glimpse of her dead lover. Thus, Del Rosario asked Esther permission. Esther refused, remarking that Varga was or cannot, as was the cause of all this trouble. One rainy early morning, Esther resolved to bring his son, who usually sleeps with Esther herself, to the 3rd room and asked the maid to let his son sleep beside her. She then proceeded to close the door. Moments after, 4 shots came from the room of the spouses. George was found lying on the bed, dead. Charge of parricide was filed against. Ayun. So, the question is whether or not Esther is guilty of parricide. Diba? When we say parricide, yung pinatay niya ang part of his family. Diba? So, is guilty kaya si Esther sa kasong parricide? Yes, diba? Because through the citations of past cases, for the identity of a person committing a crime is in dispute. The motive that may have impelled the commission is very relevant. In this case, it may well be established that the illicit relation incite the jealousy of Esther. So, the court found out na dahil sa jealousy. So, kaya napatay niya ang kanyang anak. So, as evidenced by the witness testimonies, this may be well established the motive of why Esther killed his. So, it should Murray and impossibility for the benefactor to come from the outside and supporting the claim that the perpetrator came from their house itself. Finally, the closing returns from 3rd rooms, which is not usual practice of the household, clearly indicates an attempt to conceal the felonious acts. So next case is People of the Philippines versus Geraldine P. Adalia. So on December 18, 2009, Appellant consulted Dr. Delia Potalan, Municipal Health Officer and Medical Legal Officer of Zamboanga, Negros, Negros Oriental for pain in the abdomen and urination. Appellant's urinalysis showed that she had a mild form of urinary tract infection. So Dr. Potalan prescribed antibiotic for her. But on March 15, 2010, appellant's mother, Rogelio Adalia, sought Juanita Paclarin, a manginilo, to have the letter checked. Appellant's stomach, which was growing bigger and bigger. So appellant complained that she had not had her menstruation for 5 months already. So when she touched it, she felt something moved inside. Due to her experience with her own pregnancies, she told appellant she was pregnant, but Rogelio forcefully told her that appellant could not be pregnant because she had no husband or boyfriend. So appellant also insisted that she had not had sexual intercourse with any man. So Paclarin then advised the appellant to see a medical doctor. So May 17, 2010, the appellant returned to Dr. Fotel's clinic complaining of irregular menstruation and recurrent scanty vaginal bleeding. Upon examination, Dr. Fontana noted that the appellant had an abdominal mass compatible to 5 to 7 months pregnancy gestation. When asked, appellant insisted that her last menstruation was in March 2010. Before she discharged appellant, however, Dr. Fontana told her she might be pregnant. Estrelita Abera and Angelita Paltinka similarly noticed that appellant's tummy was getting bigger. Appellant even sought advice from Paltinka on how to cure her bulging belly. Paltinka, who was 3 months pregnant herself, offered to take appellant to the hospital to have an ultrasound with her, but appellant declined. Sometime in the morning of the day, Rani Japon heard a baby crying in the abandoned shanty owned by appellant's family. He was surprised by the sound, considering that he knew that shanty was abandoned. The shanty was abandoned. Curious, he moved towards the shanty. Suddenly, the crying. So Estrelita Obera also heard a baby crying inside the abandoned shanty of appellant's family. Less than a minute, though the crying stopped, she did not think anything unusual about the cry. She only thought something strange when she heard later the day that appellant was bleeding. So the next day, on July 18, 2010, Rogelio went to Maria's house to pick up her umbrella. When Maria asked about appellant, Rogelio said appellant had given birth, but there was no baby, only blood. Later, Maroya saw appellant. When Maroya greeted appellant, the latter replied that she had given birth already. On the same day, Maroya Baltenka and Felisa Adalia went to the abandoned shanty and confirmed the rumor that a lot of blood was left there. There was also freshly dug hole. So, July 19, 2010, Rogelia confronted Maria regarding their visit to the shanty. Rogelia angrily asked Maria whether she thought appellant killed the baby. On the same day, Maria saw appellant, who also asked that she thought happened to the baby. Maria candidly told her they suspect she would kill the baby she was carrying. Appellant retorted, "Why would I not strangle it? It is better to strangle than to raise something that is due to evil spirit." So, so the question or issue regarding this case is, did the Court of Appeals gravely err when it affirmed the verdict of conviction based on circumstance evidence? So according to Article 255 in relation of the Article 248 of the Revised Penal Code, or the RPC, provides that the offense of infanticide is punishable by reclusion perpetua and its maximum period to death. But death is already abolished, so the punishment of infanticide is lifetime imprisonment. So applying Article 63 of Revised Penal Code, the lesser of the two indivisible penalties shall be imposed when there is no mitigating or aggravating circumstance which attended the killing, as in this case. So appellant claims, however, that should her conviction be affirmed here, the lesser penalty of prison correctional, not reclusion perpetua, should be imposed on her. She asserts that as the prosecution itself had purportedly narrated, she committed the crime only because she wanted to conceal her dishonor. There is absolutely no evidence on record showing that the appellant killed her child, supposedly to conceal her dishonor for being an unwed mother or a woman who bore a child, although she did not have a boyfriend. So this alleged circumstance not being found on the record cannot be used to benefit appellant by reducing the imposable penalty from reclusion perpetua to prison correctional. And accordingly, the appeal is denied. So the decision dated July 6, 2017 of the Court of Appeals is affirmed with modification. Appealing Jeveline Adalia is found guilty. So from prison correctional, kasi na-found out na guilty siya of the crime of infanticide under Article 255 of the Revised Penal Code, she is sentenced to reclusion perpetua. She is further required to pay the child's qualified heirs the following amounts: 75,000 each as civil indemnity, moral damages, and exemplary damages, and 50,000 as temporary damages. All monetary awards shall earn interest at the legal rate of 6% per annum from finality of this decision until fully paid. So with that, I will end my presentation. Thank you very much for listening.